questions. And then now I'd like to introduce our panelists for today. We're quite lucky to have three amazing speakers, and I will introduce them alphabetically. Christopher Kang is the co-founder and chief counsel of Demand Justice. He served in the White House for nearly 7 years as deputy counsel to President Obama and special assistant to the president for legislative affairs. He oversaw the selection, vetting, and confirmation of more than 220 of the president's judicial nominees, who set records for most people of color, women, openly gay and lesbian judges appointed by a president. He was also in charge of advising President Obama on communications and pardons from 2014 to 2015, and helped spearhead the confirmations of Supreme Court Justices Sotomayor and Kagan. He served as the national director of the National Council of Asian Pacific Americans, worked for Senate Democratic Whip Richard Durbin as the director of floor operations, and has received many and many honors. We're so happy to have him here today. Chris, welcome. Jamal Greene is a constitutional law expert whose scholarship focuses on the structure of legal and constitutional argument. He teaches constitutional law, comparative constitutional law, the law of the political process, First Amendment, and federal courts. He's the author of the amazing book, How Rights Went Wrong, Why Our Obsession with Rights is Tearing America Apart. He's also the author of numerous law review articles and has written in depth about the Supreme Court, constitutional rights, adjudication, constitutional theory, originalism, including rights as trumps and the Harvard Law Review Forward for the 2017-2018 term. His article, Rule Originalism, in the Columbia Law Review, and the Anti-Canon in the Harvard Law Review of 2011 are some of the most amazing and distinguished articles in the field. During the 2018-2019 academic year, he served as a senior visiting scholar at the Knight First Amendment Institute at Columbia University, where he commissioned and oversaw new scholarly research relating to free speech and new communications platforms. He has served as a visiting professor at Harvard, has served as Columbia Law's vice dean for intellectual life, and he's currently the co-chair of the Oversight Board, an independent body set up to review content moderations on Instagram and Facebook. Welcome, Jamal. Maya Sen is a political scientist and professor of public policy at Harvard University's John F. Kennedy School of Government. Her research includes law, political economy, race, ethnic politics, and statistical methods. Her research has been published in all of the leading journals in the field, including the American Political Science Review, the American Journal of Political Science, Journal of Politics. Her work has been covered by the leading publications like the New York Times, the Washington Post, The Economist, NPR, and other outlets. Her latest book, The Judicial Tug of War, How Lawyers, Politicians, and Ideological Incentives Shape the American Judiciary, with Adam Bonica. It's available from Cambridge University Press. Her amazing and wonderful first book, Deep Roots, How Slavery Still Shapes Southern Politics, is available from Princeton and won the 2019 William Riker Book Award for Best Book Published in Political Economy. She's currently the director of the Harvard Multidisciplinary Program in Inequality and Social Policy, which brings together the social sciences and the study of poverty, inequality, and economic mobility. Welcome to you as well, Maya. Okay, so three of you have thought a lot and deeply about where we are in this moment. We seem to be in a moment where people are thinking very hard about judicial reform, and reform of the Supreme Court in particular, but judicial reform much more broadly. So I'd like for you to each give me your sense of where we are, how should we think about the process, the role of the judiciary. Is the judicial system broken? How is it a misfunction in American democracy? Is reform warranted? What's your sense of where we are and why? So I'll start with you first, Chris, then we'll go to Jamal, and then we'll go to Maya.
Great. Well, thanks so much for having me. That's a lot to bite off, but let me just say, I do think that I think our courts are in crisis, and I will say that I'm not the only one who thinks this. Poll after poll have shown record low approval ratings for the Supreme Court. Gallup and Pew and others show that more and more Americans believe the court is making decisions based on politics rather than the law, and there's good reason for that. right? As you see how the court has been wrested away by political actors, with the seat being stolen from President Obama, the rules being changed to confirm Justice Gorsuch, credible allegations of sexual assault and perjury being rushed over to confirm Justice Kavanaugh, and then Justice Amy Coney Barrett confirmed just 8 days before an election after 60 million Americans had already voted. The credibility of the court is really in question. And then you sort of look at the rulings that they've had, the cases that they've taken up, many of which wouldn't have even happened several years ago. And there's a real sense of urgency with the need to reform our courts. And then when you look at the broader, that's sort of the last few years, but just the broader trajectory of how the Supreme Court has handled issues of democracy, whether it's Citizens United and campaign finance reform, Shelby County and voting rights, partisan gerrymandering, voter roll purges, making it harder to vote during the pandemic. Like, time after time, the Supreme Court, usually along partisan lines, is making decisions that are undermining our democracy and making it harder for individuals to participate. And I think that that is a very big problem that sort of then gives rise to bigger questions about what the role of our judiciary is right now, and whether or not the scope and its power are too large in the balance of government. And so I come to this from a very institutionalist perspective. I worked in the Senate for 7 years. I worked in the White House for 7 years. And it hasn't been an easy journey or a straightforward path for me. But I really have come to this conclusion that our Supreme Court is broken and it has to be reformed. And so in that vein, I think there are a lot of different reforms we can and should talk about, but the one that is most immediate in terms of restoring balance and legitimacy of the court is Supreme Court expansion. And so I think that, while a lot of other reform measures are important and should be discussed, I think it really starts with restoring some balance to the court by adding 4 seats, which can be done by legislation, and then seeing what else can flow from there.
Chris, before we go to Jamal, just so that I understand, what is the core reason why you think the Supreme Court in particular is broken?
I think there are a lot of reasons. I think that.
All right, just give me the number one at the top of your list.
I think that the Supreme Court's undermining our democracy.
Okay, all right, Jamal.
So thank you, and I'll just echo Chris in thanking you for inviting me. I think, like Chris, there are a number of problems one could point to. To answer your initial question, I don't know that I would say that the federal courts in general are broken. I might put the Fifth Circuit to one side, but I do think the Supreme Court is in deep crisis, and I think it's in deep crisis for a lot of the reasons that Chris gave. But I would combine a set of political issues, or traditionally political issues, with a set of structural issues that I think combine to make this a particularly difficult moment. The court is a very undemocratic court. And when I say that, I mean, even in comparison to other courts that serve similar functions around the world, it's very small for a court that governs the number of people it does, right? So there's 9 members, and every large country that has a constitutional court or an apex court, their court is bigger than that, than ours. It has life tenure, and life tenure is not a feature of most courts around the world. In fact, that I'm aware of, the only court in the world, the only national court in the world that has life tenure other than ours is Iceland's Supreme Court. And Iceland is a much smaller country than the US Supreme Court. The court's members can be picked in purely partisan ways. That also is not a feature of many courts around the world. They choose their own cases. So they have almost absolute discretion to choose which cases to hear. And so some of the structural features that we might think reigns in a court, which is to say it's reactive, it just hears whatever cases happen to come to it. That's not a feature of the US court, right? So you've got this really small set of justices who hear every case. They don't sit in panels, right? So every justice hears every case. It's a small sort of cabal of people who have life tenure. They then can pick their replacement, essentially. So that's deeply undemocratic. It's been undemocratic for a long time. But you combine that with the fact that you have a situation where Democrats have received more votes in 6 of the last 7 presidential elections, but they've only had 5 of the last 20 Supreme Court picks. And the conservatives on the court adopt an ideology that is fairly explicitly opposed to democratic control. It's a very kind of deeply substantively anti-democratic philosophy, and that's a sort of a crisis, right? You've got this really kind of almost monarchical body of people who make democratic decisions, anti-democratic decisions, and then perpetuate themselves by choosing the timing of their replacement, and that I think is an unsustainable situation.
Okay, just a very quick follow-up, as I did with Chris. And by the way, let me just invite folks in the audience. Please feel free to ask questions through the Q&A function. We welcome your questions. All right, if I can understand what you mean by anti-democratic, Jamal. So from you hinted at this, I wasn't quite sure. What is it more anti-democratic than it used to be? Is this always, has something changed? But perhaps more importantly, compared to the other institutions in American democracy, say compared to the Senate, compared to the gerrymandered House, right? In what ways is the court an outlier, or to what extent is the constitutional framework that has given us our major institutions really inconsistent with our modern conceptions of democracy and responsiveness? The court may or may not be a part of that, but to what extent is it really an outlier, whether from a temporal perspective or from an institutional comparative perspective?
Well, I think it's an outlier in both respects, which isn't to say that it has ever been democratic. It's to say that there are particular issues arising around both its own self-conception in terms of how it actually perceives its role, how confrontational it is in respect to things that Congress does and things that the administrative state does, but also just the trend, because people can pick their own replacements and not every president gets to pick a justice. It happens to be the case that Republicans have overwhelmingly dominated Supreme Court selection in recent decades, even though they haven't dominated presidential elections. And so that creates a gap between where the court is ideologically and where the country is. As compared to the Senate and the House, of course, those institutions have their own pathologies and are not as democratic as anyone, I think, would reasonably want them to be. But members of the court are not elected and serve for life. That is different in kind than people who have to stand for election. So I think that I do think it's a significant difference from other institutions.
Maya.
So hi, everyone from across Harvard Yard over at the Kennedy School. Thank you for having me. I think this question about whether the judiciary or the Supreme Court is broken, I think the answer to that is very subjective. I think people from across the political spectrum, if you ask them that question, will give you very different answers. So I think many more Democrats are likely to say that the judiciary is broken than are Republicans. So I think it's important to keep in mind that the answer to the question, how we approach the question, will get you different answers, because I think how people think about that question is very subjective and it's filtered through their partisan and ideological worldview. And right now, partisanship rules everything, right? So everything is politicized, and how people view the judiciary is politicized as well. So coming at this question from a political scientist, I think a useful sort of objective way to think about it is, are the courts representative ideologically of what this country looks like? And a useful way to, again, get traction on this is to kind of look at what the evidence tells us, right? And so right now we have the median justice on the court right now is, it's Brett Kavanaugh, essentially. Sometimes I think Neil Gorsuch kind of slips in there, but it's generally agreed, most scholars agree, that it's Brett Kavanaugh who's serving as the important pivotal median member, right? So his preferences really dictate where the court's opinions generally fall. And Brett Kavanaugh is very conservative. Like, let's not mince words about that, right? So we have a median member of the court who's very much to the right of most Americans. Most political science measures that I've seen put him somewhere rightward of Mitt Romney, right? In terms of kind of placing justices on the same scale as politicians, which is, I think, more understandable for members of the public. He's like more conservative than Mitt Romney, probably less conservative than Rand Paul. But if we zoom in on the 6 conservatives, the median of those conservatives is probably like Amy Coney Barrett, and she is actually around that ballpark of Rand Paul and people like that. That's very conservative. And that's very much out of step with mainstream American political ideology. And so I think that we're sort of talking about this issue in the absence of politics. It doesn't really make sense to me as a political scientist. When we ground it in politics, we see that the court is really out of step with where the average American really is. And when that happens, then you start to see kind of the court being consistently out of step in terms of its rulings, in terms of the policies that come from those rulings. And that's when you get that friction between what most people want to see from their court and what the court is actually producing. Now, I think along with that, the problem, I think other panelists have kind of nailed this on the head. I think the real crisis is not so much the court is simply out of step with public opinion. It is. But the real problem is that the court's nexus of power in that conservative majority is also positioning it well. The conservatives in that bloc are well positioned to rule on very important voting rights cases, right? So if you have such a strong conservative majority that then is kind of passing judgment on what puts politicians in power, right? The democratic process, then that's, I think, that's the path that we're on that I think makes a lot of people very uncomfortable. Now, again, going back to this, is this a crisis? I think it depends on who you ask. Because if you're a Republican in Congress right now, you're very happy about this. This is not a crisis for you. This is actually something that you want to, that this is going to be beneficial for you politically. So I think it's very important to always kind of realize that this is a subjective question. The other thing I'll say is that this is something that Jamal said earlier. I think it's very important to emphasize that this is a small number of people we're talking about, 9 people. So a decision by one person to retire can kind of tip the balances very quickly over time. What we've seen is that there's, at the Supreme Court at least, there's been members of appointments by one party have been, I guess, more strategic, shall we say, about their retirements. And just 1 or 2 of those retirements is enough to shift the balance of power quite radically. To me, that means that thinking about whether the courts are broken, I don't know if they're broken per se, or if that's the right way to think about it, but I think it's true that there are institutional features about the Supreme Court and the American courts writ large that really open things up to political gamesmanship. And if members of one party are better at playing that political gamesmanship, things very quickly kind of spin out of control, and it becomes very lopsided in terms of partisan or ideological balance. And I think that's the environment in which we are in now, where the court is just simply not representative of American ideological interests.
So my question for you. So one option is to impose external structural reform, but one option is there are 2 other possibilities. One possibility is that the asymmetries that we see between the partisan actors, right? The Democrats start behaving much more like Republicans in how they think and approach, say, retirements or judicial appointments. And in some respects, you saw this with a lot more pressure on Justice Breyer than probably there was, right, on Justice Ginsburg, and people learned a lot from that. So you're seeing some learning effect, and probably less, maybe the gap is not going to be as much. The other question is, look, if the court gets too far out of step, then wouldn't there be an internal or external discipline effect that forces it to get back, right? So to what extent is sort of extra judicial reform necessary, particularly given the partisanship that you're talking about, right, which is going to make all of these things viewed from a partisan lens?
Okay, so is the asymmetric nature of the retirements, the asymmetric nature of how the parties are approaching this changing? I think that you're right that we saw way more pressure on Justice Breyer than we've seen on, certainly that we saw on Justice Ginsburg than we've seen recently on other justices. And I thought that as a non-law professor, I thought that was very interesting to watch. And I think we can talk about this more in Q&A, but I think it signals a generational change in how legal elites on the left side of the aisle are kind of viewing the Supreme Court. I saw the call and the criticisms of Justice Breyer primarily coming from younger academics, from more progressives, the more progressive wing of kind of the legal elite. And so I don't think that there's the equivalent strategizing on the left that there is on the right. But I think that's more of a generational change, and I think that will develop over time more so. So, I mean, I'm happy to talk more about that. I think that's very interesting. Like, I think the question on whether the court will self-adjust to be more in line with public opinion, like the switch in time that saved 9, I don't see much evidence that the current court is inclined to follow that example. Maybe, Justice Roberts, I think, is very mindful of the legacy of the Roberts Court and what people will write about him. But I don't get the impression that the other members of the conservative voting bloc are thinking about restraint at this moment. I think it's sort of the opposite, that they've had a couple of years under their belt where there was some restraint, where the court was viewed as surprisingly moderate by observers. And now it's sort of the time to exercise the power of that 6-3 majority. But I think this is like, I think the other people on the webinar are experts and can really speak to this, but I don't see much of a sense that there will be that kind of restraint.
Jamal, if I could pick up with the first point that Maya made on that change in legal mindset from legal elites and legal academics in particular. In many respects, you're a leading constitutional academic of your generation. You have all of the traditional credentials, Yale Law School, Supreme Court clerkship, Harvard Law Review placements, right? Sort of like, right, from a traditional perspective, you, in many respects, you sort of represent the apex of the legal elites. And yet here you are talking about the need for judicial reform, especially at the Supreme Court level. Although my guess is maybe in 2 or 3 years, you might change your mind about the lower courts as well. But let's put that right, because it's not clear that the Fifth Circuit, maybe the Fifth Circuit is a leading indicator. Okay, but let's leave that aside for the moment. Do you think something has changed in how legal elites and legal academics think and approach the court? So like, is the reverence for the Brown era really over with sort of folks in my generation and higher? So like, how is it that you've come to think about this question?
So I do think that we're certainly in a different place than the sort of legal elites are certainly in a different place than they were 30 years ago. I would say,
and left legal elites too.
Left legal elites, but right on the right as well.
Right.
I think, but for in different ways. Insofar as I don't think that, I think that's related to specific things that the court has done and specific features of our politics, right? So, seeing landmark statutes like the Affordable Care Act being threatened and escaping by the skin of its teeth, seeing the Voting Rights Act being invalidated, and then seeing, I think that the modern court reform movement has been deeply affected by what happened with Merrick Garland and the replacement of Justice Scalia. I think that was very much a wake-up call about the nature of the political process associated with nominating and confirming justices. Justice Kennedy was confirmed nearly unanimously by Democratic Senate. Clarence Thomas was confirmed by Democratic Senate. I don't think anyone thinks that if the Republicans were to control the Senate after the midterms, that they would even entertain a Supreme Court pick by a Democratic president, right? So that's a very different. So in terms of pressure on Justice Breyer, I mean, that's what that if we were still in 1988 and one could expect him to get not just some votes, but a majority of the votes from on the Republican side for his Supreme Court pick, then people would feel less urgency, I think.
Thank you, Chris. I'd like to pick up on the reform point, and it's something that Jamal mentioned and its effectiveness, even before going to the court expansion idea that you threw out in your opening comments. Why do you think what is it that the reform effort has done so well that has really brought this question into the consciousness of many Americans, maybe left-leaning Americans, certainly forced the then new President Biden to appoint a commission to think through these questions. So what are the strategies that have been used, and to what extent can those strategies be used to, in fact, implement the types of reforms, and we can talk about those specifics in a moment, but to implement the types of reforms that the reform movement is seeking and looking for?
Thanks. So my organization, Demand Justice, was started in 2018 to try to approach these judicial nominations and confirmations in a different way and address this glaring asymmetry between how the right and the left approach judges. I'd like to be able to take a lot of credit for spurring on this movement for court reform, but I think the reality is that the credit goes to Donald Trump and Mitch McConnell and the Republican justices on this court. I think that when you look at how the reaction has been to watching, in particular, the confirmation of Justice Kavanaugh, and the willingness to disregard, again, credible allegations of sexual assault and perjury, Republicans could have found an equally, maybe even more conservative justice to fill that seat, but they didn't, because they sort of thought that they could just plow through it and paper over the allegations. And then again, I think when you really saw the momentum was this idea that after taking the seat from President Obama and saying we can't possibly consider a Supreme Court justice in the final year of a president's administration to then consider one in the final month of another, really crystallized the hypocrisy and really about how the Republican Party treats the Supreme Court as from a partisan perspective and from a power perspective. And now you see, I think in particular, I mentioned that the Supreme Court has its lowest approval ratings. And I think that Maya is right, that the reason why we have the low approval ratings is for a long time, Democrats have been the ones that have been holding up the approval, because it's sort of, we tend to believe in institutions and want to support institutions and the good work of government. But watching in particular what the Supreme Court did in Texas by allowing this abortion ban, which is still in effect now, to go into effect and to take part, that is where you saw the sharp drop in approval for the court. And I think we're going to see it again here in June, whether it's outright overturning Roe versus Wade or at least gutting access to abortion, whether making it harder for states and localities to pass gun violence prevention. The big case they just heard yesterday regarding the EPA and the ability to pass regulations or enact regulations around climate change. These are issues, again, where we talk about whether or not this court is sort of like behind public opinion, whether it's going to change. This is part of the Republican project, right? The project here in creating the 6-3 supermajority on the court is so that the court can do things that the democratically elected branches of government could not. And so certainly there's a lot to be said about whether or not the House and Senate are sufficiently democratic institutions, but they did pass the Voting Rights Act. They did pass the Affordable Care Act. They would oppose Roe versus Wade being overturned, or they support gun violence prevention. These are the things that this court, I think that the court's going to do what it was installed to do, which is to implement this hyper-conservative agenda. And I think that is what, I think come June, unfortunately for our democracy and for our country in the meantime, I think that the conversation and the debate around Supreme Court reform is going to be taken as a given by the end of this term. And then the question will be, what should we do about it? And not what I think it's been over the past couple of years, which is whether or not it needs to be reformed in the first place.
So Maya, here's a question, given the polarization and partisanship, and effective polarization, negative partisanship, however one wants to characterize it, right? All of these things that are going on. What is the prospect for reform in a world of such depolarization, where one side is going to be happy with the status quo, the other side isn't, and even the nature of the discussion of these issues can only be framed and understood in partisan terms?
So I'm so glad you asked, because I've actually done some work looking at this exact issue and trying to figure out where people stand vis-a-vis the Supreme Court. So one thing that's been interesting from an academic perspective over the last 3 years is that the court has shifted pretty strongly to the right, but we've been able to capture that in terms of how the court has moved with regards to public opinion. So I have a working paper right now looking at exactly this question, and we show that the court has indeed moved to the right compared to public opinion. It's actually moved much more in sync with right now where the Republican Party is. So we ask a variety of questions of Republicans that are designed to look like the issues that the court rules on. So we ask them what their attitudes are on things like voting rights or abortion rights, and we try to mimic the questions so that they look like the issues that the Supreme Court rules on, and then we can compare people's answers. And the Supreme Court tends to rule kind of in line with what Republicans want to see in terms of these key questions on reproductive rights and voting rights and LGBT rights and so on and so on. So the court has moved pretty squarely in the direction that puts it right in the middle of the Republican Party's preferred policy positions. Now, what's interesting is that if you ask people, well, what do you expect the court will do on these sorts of issues? It turns out that Republicans actually are pretty accurate about predicting how the court will rule. They're actually pretty good at it. It's Democrats who consistently think that the court is more liberal than it actually is. So Republicans actually get it right. They think the court is conservative, and they accurately predict the court being conservative on these issues. It's Democrats who consistently think the court will rule in a more liberal direction than it actually does. Now, what we've seen over the last couple of years is Democrats are actually correcting on this. They're updating. They're looking at, the Texas abortion case or the various COVID regulations that have been struck down and things like that. And they're actually updating how conservative they think the court is. It turns out that in terms of reform, and here's where I'm getting to the reform part. It turns out that the distance between, like, from the perspective of someone in the public, a member of the public, the distance between you and the court, so how far away they are from you in terms of your preferences, that's what predicts support for court reform. So right now, if you are quite liberal and you think that the court is very conservative, you are more likely to support court reform. Now, because Democrats have actually been historically quite bad and have historically underestimated how conservative the court is, they've actually been less likely to support court reform. But as they're starting to update in the last couple of years on how conservative the court is moving, they're starting to support court reform attempts more and more. And we're actually picking that up in the data. As over time, Democrats are becoming more amenable to the idea of court reform as they're coming around to understanding that the Supreme Court is actually deviating quite a bit from their own policy preferences. So going back to the question that you asked, I anticipate that in the next couple of years, I think Chris is right. I think support for court reform and court curbing, I think, is going to become more widespread, but it's going to become more widespread among Democrats. Whereas Republicans, who actually are amenable to some of the ideas behind court reform, in particular term limits, the partisanship is going to sort of kick in, and they're going to become more recalcitrant about it. They're going to become more opposed. So I think in the next couple of years, court reform is going to become a polarized issue, like so much of US politics. I think what this means is that, Democrats are going to become more enthusiastic, Republicans less so. Where will that leave us? I think that depends a lot on the balance of power in the White House and in Congress. But I think it is going to become very quickly polarized here in a couple of years.
Great, thank you. Though not optimistic in some respects, right? Jamal, so we're going to go to the Q&A, and so they've got a list of questions. So one question for the panelists is, how should we change the nomination and confirmation process to make it less partisan? What thoughts do you have along those lines?
So a few thoughts, and I guess part of the question is whether we're talking in ideal terms or talking about what's actually politically possible. To take the second point first, I do think that at least over time, in the next over the next few years, it may well be conceivable that something like term limits is possible. Again, the U.S. Supreme Court is basically the only court in the world that doesn't have term limits, or doesn't have a retirement age, and there's support on both the right and the left for term limits among scholars, among lawyers, among politicians, among people who've studied this question. It's perceived, because Democrats tend to support court reform more than Republicans. It's at the moment sort of perceived as a kind of a left push, but it's not inconceivable, since the case for it, I think, is very strong. Now, there's a really important and difficult question of whether it can be achieved by statute or whether it would require a constitutional amendment. Obviously, passing a statute would be easier, but would also have a litigation risk associated with it. It could be struck down by a court at some point. But some movement in that direction, I think, is conceivable. I don't know if I'll say likely. More broadly, and here's in the realm of the not particularly conceivable, at least not in the short term, I tend to be in favor of. I think you can't take partisanship out of the Supreme Court process in this day and age without making the court's members less powerful. And so I think the way to do that is to make the individual justices less powerful individually. That means term limits. That means many more of them. And I support a bigger court. I don't quite support partisan court expansion, but I do support a bigger court, and one that sits in panels, right? So that you don't necessarily know who's going to be sitting in any individual case, right? And so that makes the stakes, the partisan stakes of any particular confirmation much lower. One idea that sounds wacky, but I think is actually a very good idea is that you make all of the courts of appeals Supreme Court justices, and then who sits on cases is just a subset of those particular justices, and you could pick that subset in any number of ways. That would not depoliticize the court. There's no way of doing that. It is inherently a political institution, but it would, I think, dramatically lower the partisan stakes of any individual confirmation.
Great. My colleague Pedro from the Ash Center is keeping track of questions. So Pedro, I'll turn it over to you for the next set of questions, if you don't mind.
Yes, absolutely. Thank you so much. So the first question we have is actually for Chris. Chris, do you think, or how do you think the report from the US Commission on Supreme Court reform will actually affect grassroots movements and strategies? And I'm also gonna add another point from another question here. Why can't the Democratic side organize themselves as effectively for the long game instead of looking for easy big wins? So basically, has the report changed in any way the way grassroots movements for court reform are acting, and why going for small wins other than long-term changes?
So with respect to the commission and the report, I do think it was helpful to the extent that, again, I think that there has been a debate about whether or not reform is necessary. And so I think that the president creating a commission to discuss this issue helps shine a light on the fact that this is an ongoing debate. Notwithstanding that, though, I think that sort of from the makeup of the commission, including the fact that it had skeptics of court reform on it, it sort of curtailed what you were trying to accomplish. So then there was debate about whether or not reform was even necessary. And then I think really, unfortunately, the report, the mandate from the president didn't allow the report to even make recommendations. And so it's a great historical study of court reform past and sort of the debate of now, but I don't think it really changes any minds. I don't think it really has a great impact on whether or not, sort of certainly not activists. I think most activists who think about the court, to Maya's point, it's sort of a little bit more based on your political and partisan preferences right now. I think most grassroots activists that we've been talking to face great frustration with the report and the fact that it took 6 months to just come up with a study that says that some people think that court reform is necessary and some don't. And so I think now that that's past us, hopefully we can continue to start talking more about what the solutions are and how Congress really is the place to take the next step and how we can do so. I think one of the issues too, and this gets to the question that Jamal just answered too. One, I completely agree in terms of the policy prescriptions and making each confirmation less weighty as a way to maybe address some of the partisanship in each of these confirmation battles. But I think part of the challenge here, and this comes to the other question, is I think that Democrats often think like the way to make something less partisan is for Democrats to unilaterally try not to make it partisan. But that only broadens the asymmetry, right? If one side tries to make it less partisan and the other side tries to make it more partisan, that doesn't actually make it less partisan. And I think that Democrats are starting to come around to this mentality. And I think in particular, as we saw President Trump and Republican Congress dismantle norm after norm after norm, things that we sort of took for granted in the conduct of our government, I think Democrats are recognizing now that once one side abandons a norm, it's not a norm anymore, as much as we wish it were. And so we have to adapt and we have to work differently. And I think that it's just taking some of these wake-up calls to get Democrats to come around. And so I share I'll read into perhaps frustration of the questioner that Democrats haven't come around to it as quickly, but taking just a slightly long view, filibuster reform was a very extreme position just 3 years ago. Only a few Democratic senators supported it. Now it's the position of 48 Democratic senators. And you see almost every single major Democratic Senate candidate is running on reforming the filibuster. So I think there definitely are these seismic shifts happening with respect to how Democrats understand and start to wield power, and how we're sort of hopefully be able to use it to enact more small d democratic reforms.
Yeah, I just have one quick follow-up. Do you think that it had an element of demobilizing grassroots movements? Very briefly before I move on to the next question.
I think that the commission, I assume you're talking about the commission, I think that the commission sapped some of the energy because it made it very easy. One of the things we've been doing is having constituent meetings with members of Congress. Demand Justice Volunteers has met with more than 100 members of Congress, and the response all through the summer was, we're going to wait for the commission. We're going to wait for the commission. And it had this ability of allowing everybody to punt the conversation down the road. And so it did. It sapped a little bit of that energy. It sapped the outrage that people rightfully felt after Amy Coney Barrett was confirmed in the midst of a presidential election. But again, I think that having that report come out right on the heels of the Supreme Court's decision in the Texas abortion ban, and in the midst of this term, I think it'll sort of be a bookmark later, but the momentum and the need for reform, I think, is picking right back up. Thank you.
Thank you so much. The second question to Professor Jamal Greene. Jamal, can maybe you speak about the Professor Nico Bowie's argument in favor of narrowing the court's power of judicial review? I know there has been a huge debate in the UK about restricting judicial review of courts after Miller won and all the Brexit debates, but I wonder what do you think about it in the UK, in the US, I'm sorry.
Sure. So, and I'll say just a couple of things. So one is just in practical terms. If we're talking about Congress passing a statute that limits the jurisdiction of the court or requires a supermajority for striking down laws or something along those lines, I don't have any doubt whatsoever that the current Supreme Court would ignore or invalidate that kind of statute. They would understand that to be a violation of the separation of powers. That said, the Congress has controlled the jurisdiction of the court in various ways many times in the past. This would be an unusually aggressive exercise of that power if it were substantive, or if it said over certain, all congressional statutes don't get judicial review or something along those lines. That would be more aggressive than it has been in the past. Just speaking in wearing my constitutional law professor hat and my sometime teacher of federal courts hat, the question of whether Congress and to what degree Congress can restrict the jurisdiction of the court is kind of the central question in federal courts, which is to say it doesn't have a clear answer. There are people who line up on both sides of this question. So without getting deep into the weeds of analyzing Article 3, it's to say that it's a very controversial question, but that the court has its own self-interest in answering in a particular way.
Dirk, can I just weigh in on that too? Because I think the impact of such a rule change has to be really evaluated with regards to who comprises the 6-3 majority on the court, right? So a 6-3 rule that you need 6 votes to overturn an act of Congress would completely disempower the liberal members of the court. They would never, like in our lifetimes, they would be unlikely to have the numbers needed to overturn an act of Congress, whereas the conservatives already have the 6 votes, right? So the question is, do you trade off, like if you're a liberal or a Democrat, you do trade off the ability of liberals forming a coalition in exchange for shifting the median position from Brett Kavanaugh to John Roberts? And I think that's like sort of the question that you have to ask yourself if you are serious about pursuing such a strategy. Is that worth it to you? Is it worth it completely disempowering liberals from forming a majority to overturn an act of Congress that could be a very, down the road, it could be a very conservative Congress seriously infringing on minority rights, but the court would be completely disempowered from overturning it under such a rubric. So I think I think the political considerations, I think, require thinking through some of those trade-offs.
And can I just briefly add just one point, which I completely agree with Maya, that those are the trade-offs that one would have to consider. I'll just note that at least in recent history, there's been an asymmetry in the degree to which conservative versus more liberal or progressive interests want to overturn acts of Congress. And so how much do you pursue your policy agenda through congressional acts versus pursuing it through the courts? At least again, in recent decades, that has favored Democrats pursuing their agenda through Congress. That could change, and there could be specific acts that one would want to keep in mind, but I just wanted to make the point that it's not always symmetrical.
And I would just add that this is sort of one reason why I think that Supreme Court expansion is a necessary piece of this. One, I completely agree with Jamal that this court's not going to find reforms like that constitutional, but a more balanced court might. And then if you had a more balanced court, I don't mind if the Supreme Court is more disempowered. It's not for me just because the court currently has a 6-3 Republican supermajority, even with a Democratic majority. I think that sort of the arc of the court, as Jamal said, like this is not a recent phenomenon that our court has been anti-democratic. I think that there's a lot to be said for a lot of these other reforms, regardless of who's in power.
Thank you. Thank you so much, Chris, Maya, Jamal. Maya, I'm gonna ask you a question now on the effects of institutional design, and probably from an empirical perspective, you're able to foresee what would happen. So we received questions about the adoption of term limit. How do you think the politicization of courts and how would electoral cycles actually affect the court in case term limits are adopted? And what's your view on the adoption of term limits? And also, I'm going to add a second question already. President Biden just nominated Brown Jackson to the court. And it seems that there was not strong discussions about judicial diversity in the Supreme Court or the adoption of an institutional design or a few incentives or commissions looking at that specific topic. And I wonder what are your thoughts on that as well, because I know you are an expert on the subject.
So there's a lot of really interesting work right now looking at the potential impact of various court reform proposals. I think one area where we need more work are these kind of limits on jurisdiction. But we do have a lot of good evidence on what a court under term limits might look like and what a court under court expansion might look like. And I actually I'm a pretty big fan of term limits. So I think if the goal is to have a court that roughly reflects the preferences of Americans, I think term limits is an excellent strategy. And the reason why is because term limits regulate appointments, right? So it leaves less to political gamesmanship and strategic retirements, and it actually just regularizes the process so that each president gets about 2 appointments, right? So each presidential term would get 2 appointments and so on down the road. The justices would be term limited. Usually most of the proposals are 18-year term limits. And so a group of us, so Adam Chilton, Kyle Rosema, and Dan Epps have done simulations on what the court might look like under different term limits proposals. And the benefit, I think for all of the plans that are being considered, the benefit of term limits is that it reduces the ability of any one of the parties to gain a supermajority. Like it reduces what we would call extreme partisan imbalance on the court. So it keeps the center of the court roughly in line more or less with where the American electorate is. And it keeps it more in line with kind of that public opinion that lends the Supreme Court legitimacy and support. So I think that's the real benefit of term limits, is it keeps the court from getting too far out of line with where the American public is.
Can I ask you a question about this? Because you're not just a political scientist, you're also a lawyer, even though you try to disclaim it, but we'll claim you. So the one notion of the court, especially the apex court, is that it ought to sometimes operate in counter-majoritarian ways. Right? So we don't always want a court that is reflective of majoritarian preferences, especially because we have institutions that are supposed to be reflective of those majoritarian preferences. So adding that as a set of variety within our institutions, and the assumption is the court will protect minority views, minority rights, at times in which we may not recognize that we need that protection, but we'll do so. So how do you reconcile sort of like those 2 notions? One is of a preference for reflecting having yet another institution that is majoritarian, but with the need for institutions that also protect minority rights, a task delegated specifically to the Supreme Court.
So I've been doing some thinking on this question because I think it's an important one. I think I've been really influenced on this by the work of Nico Bowie and other people who sort of pointed out, I think very compellingly, that the court's protection of minority interests usually extends to the protection of property and power. And that's sort of historically been the case, with a few blips here and there, like the Warren Court, the striking down of the Defense of Marriage Act and things like this. But for the most part, the court's exercise of the protection of minority rights has been a fairly conservative one, I think. I'm actually working on a paper that tries to show this, not empirically, but using kind of qualitative evidence. So I think, like, I understand the notion that it's not meant to be a representative institution, but I think we also need to think critically about the interest that it does protect when it claims to be protecting minority rights. And they're not often the rights of racial or ethnic or gendered minorities. They tend to be the rights of the minorities who own a property, who have power and are sort of looking to increase their share of the pie. So I think I would take issue with the court being an ideologically neutral protector of minority rights, and kind of think, or just to think more realistically about the position that the court has occupied in that regard. Can I just respond briefly about the diversity issue? I think it's really interesting. So for those of you who are interested in this, there's a wide variety of papers and scholarly studies looking at the impact of a judge's race, ethnicity, gender, professional background on their judging. And I think one of the things that's clear from this line of work is that a judge's background does tend to predict the kinds of cases that, how they will rule on certain kinds of cases, but it does so when the case has a component that engages that part of their identity. So for example, we know that female judges vote differently from male judges, but they do so primarily when gender has some component in the case. So it's a Title IX case or a reproductive rights case or a sex discrimination case in employment or something like that. There's some component about the case that has a component of gender. And one of the things that's very exciting about Judge Jackson's appointment is that as a Black woman, so many topics that come before the court will engage that. There's so many cases that involve race, gender. We were talking about, voting rights, affirmative action, abortion rights, LGBT rights. All of these sorts of cases will engage that those parts of her identity. And so it's very exciting to see how, if she's confirmed, how she will go on and express her voice, and how we will be able to see that the variety of her experiences and her identity reflected in her rulings. It's very exciting.
I think that's exciting, but since you didn't plug your most recent working paper, I'll do it for you. I think the other thing that's really exciting is that Judge Jackson would be the first former public defender to serve as a justice. And I think that this is, in particular, when we look at professional diversity and you look at President Biden overall, how he's approaching the courts, not just focusing on the fact that 75% of his judicial nominees are women and 2/3 are people of color, but 60% are professionally diverse, meaning that they weren't prosecutors or corporate law partners, which is where presidents of both parties have tended to select their judges. And I think that 30% of President Biden's judges have been public defenders, including now Judge Jackson to the Supreme Court. And that's an incredibly important aspect of the diversity. And so Maya has a working paper out now. I don't know, you have a lot of working papers out now. It's amazing how much, tireless you are. But this is really interesting because it looks at how judges with public defender backgrounds handle, in particular, sentencing, and in particular, extremely long sentences. And it really gets at this idea that, again, when we think about the direction of the law and we think about how courts have moved in a direction in criminal justice where you have things like qualified immunity, which is a court-made doctrine, you have different issues where it has not benefited. The Supreme Court itself has not had a justice with any criminal defense experience in the last 30 years. I think that empirically, we're starting to show that having more professional diversity is also going to have a really big impact, hopefully, on how the law develops from the Supreme Court all the way down.
Thank you. Maya, just a follow-up. When we're discussing court reform, and specifically the Supreme Court reform, and we think about how judicial diversity impacts outcomes, legitimacy, judicial decisions, is there something in terms of institutional design or any sort of incentives that you think would be worth thinking about and that are not in the current reform debate discussion?
In terms of diversity?
Yeah.
I think to be honest, I actually think the incentives are there. So if we kind of go back in time, it's been the case for the entirety of American history that presidents have used judicial appointments to curry favor with different parts of their political constituency. For a long time, that was just exclusively men. And then for a long time after that, it was primarily, college educated white voters. And now the electorate has opened up and people are demanding different things from their governing institutions. There is actually some evidence that I've not yet written this working paper, but there is some evidence that I found that people do tend to prefer governing institutions to reflect diversity. And they do prefer it to be roughly kind of moving in line with what they see in the general population. And I think there's some evidence also that courts are part of that same pattern, that people want to see in the courts and in the judiciary something that looks like demographically like the US population. That's particularly the case for racial and ethnic minorities. They want to see that kind of representation. So I think if you're a president and you care about the constituencies that are involved here, you care about the votes, to be politically pragmatic, then you're going to want to care about making those sorts of appointments. So I think the incentives are actually in place already.
Thank you. Thank you so much. Guy, up to you for the final minutes.
All right, perfect. Okay, so I'd like to just give you all, thank you, Pedro, your final thoughts on where you think we are going to be 3 to 4 years down the road on the question of court reform and how you think we're going to get there, right? So we'll give you each a few seconds to give us your best prognostications. Maya, if you don't mind, we'll start with you, then we'll go to you, Jamal, and then Chris will end with you.
So I think the topic of court reform is going to be increasingly salient in the next couple of years as the court continues its rightward shift and continues to move out of line with the majority of Americans' public opinion. Now, that said, I think opinions about court reform will sharply polarize in the next couple of years, so that basically, I think we're going to get to the point where mostly Democrats support court reform and mostly Republicans oppose it. I think that's going to be very hard politically to navigate in terms of finding a consensus given the filibuster. So I think there's going to be, in the next 3 to 5 years, I think it's going to be a serious impasse, but we're going to be talking about it a lot more.
Thank you, Jamal.
Well, I very much agree with that, assuming we are a country 3 to 5 years from now. And I don't just say that facetiously. It's just that there are so many other issues that I think might overwhelm court reform, and it may in part depend on the court's performance in response to those particular issues. So if there's some issue around the election in 2024, how the courts perform in relation to that, I think will affect a lot of what we're talking about. But of course, even this term, as Chris just talked about, right, we've got all the major issues: abortion this term and the next term, abortion, affirmative action, gun control, climate change, the Voting Rights Act, right? It's all on the table. And what the court, I fully expect the court to issue a number of very conservative decisions. There will be more calls for court reform. And I think if Democrats have control of the seats of government, which is of course very uncertain, that I think there'll be a strong move for at least something along the lines of term limits, which will then be challenged in the courts.
Chris.
So I think to pick up on Jamal, I don't know what the time frame is, but assuming we still have a country, and the next time Democrats control the House, Senate, and the presidency, I don't think the filibuster is going to be here then. I think that the filibuster is, will soon be relegated to the dustbin of history, and we're going to pass a lot of democratic reforms, including court reform. I mean, right now already we're seeing this trend that Maya identified. 70 to 80% of Democrats support Supreme Court expansion. I think sometimes we go into this with the notion that it's extremely unpopular, and in the Democratic Party, the base, and more than the base, I think 80% of Democrats are already there. And so we have legislation introduced in both the House and the Senate. The House bill has almost 50 co-sponsors. It's endorsed by the Congressional Progressive Caucus. The momentum is definitely there. Whether or not it crests to the point where the legislation could be passed before we lose a chamber or two of Congress, I think will be the open question. But the next time we have this trifecta, I think that the groundwork that's been laid on the filibuster with respect to voting rights, I think you'll sort of put a period at the end of that sentence, and Congress will start to be able to pass some real legislation that supports our democracy, and the court reform will be central to that effort.
Chris Kang, Jamal Greene, Maya Sen, thank you so very much on behalf of Pedro, myself, Harvard Law School, Kennedy School, Ash Center. Thank you all for joining us, and thank you for fascinating and stimulating conversation. All the best to you.
Thank you.
Thanks so much.